Good evening, everyone. My name is Simran Khanna, and I welcome you all on behalf of Team Knowledge Steez for the webinar on Right to Information Law, Uses and Misuses. Today, we have Advocate Sanjay Kumar Chadha sir with us as our esteemed speaker. Mr. Chadha is founding managing partner in the litigation, arbitration, and compliance group, mainly labor and law compliances of BSK Legal. His area of practice focuses on civil and commercial disputes, labor and employment laws, intellectual property litigation, consumer protection, and commercial criminal arbitration. Under his supervision, at present, the firm is successfully handling all kind of cases in over 614 districts throughout the length and breadth of the country. Mr. Chadha is also looking after the labor and allied law compliances for many clients, including of India's largest private sector life and general insurance company, ICICI Prudential and Lombard, and many more. He is passionate about sports and culture promotions. He is a member of Sahitya Kala Parishad. Mr. Chadha completed his masters from Sri Ram College of Commerce in the year 1992 and LLB from Campus Law Center in 1995. He is a member of Bar Council of Delhi, Delhi Bar Association and Delhi High Court Bar Association. Mr. Chadha has made representations before Supreme Court of India as well as various high courts. We welcome you to the webinar, sir.
Thank you very much to you, and I also thank to the organizers of this webinar, and would like to start. I would also like to. I can see Mr. KVJ Rao is there. I would like to thank him for his presence as well. Thank you very much, sir. Now today, this opportunity is given to me to speak on one of the, I would say, after independence, one of the most important legislature after independence, as I would say. We all know that India is the biggest democracy of the world. We are at the top, and from last 70 years, we are running one of the best democracies and improving upon its quality day by day. Now, as if I may begin with it, that right to information is one of the fundamental rights, one of the most important fundamental right in the sense, not exactly as enshrined in the Constitution of India, but most fundamentals of the most important statutory rights for its contribution for democracy, if I may say, is the most important. It is known to everybody that an informed citizen is what will make the democracy as strong as possible. Other day I was speaking with somebody else and said that what this RTI has done. I said this RTI has given right to each and every citizen, be it down the line, the most suppressed citizen has also the right to ask the topmost person in the country as to why this thing has happened, what is happening in any of the realms. A rickshawala can ask Delhi University what is the funds you have and where you are allocating these funds. So from any public authority, if I may say, you can very well, you means any citizen can very well ask anything, any information. And what I feel that this information give you, first, you were not having the information from where you will be asking the question. Where will be the question mark the first and foremost thing for asking any question, which is one of the essentials of democracy, strong and vibrant democracy, if I may say. If you feel that your democracy is vibrant, then you require to have such kind of law information. This is, if I may say, that there is a transparency index all over the world, wherein still our country is quite at the back. We are about 60th in that, and the country from where it has started, it is Sweden, if I'm not wrong, is at the first stage. That is just for information. So what on in the year 2005, we saw this excellent legislature was passed on 12th of October 2005, to be very precisely. This law came into force, wherein, as I always say, that this law has provided a practical regime. Now I'll come to this. What is practical regime? Very important to understand that this has created a practical regime of right to information for all the citizens. Mind it, it is available for citizens only, to secure access to the information which is under any public authority. This is what is broadly in gist, if I may say, what RTI is, Right to Information Act. Now, what is practical regime? One is that a right is given to you, and with that right, what you do is that, we have seen a right is given, but it is very difficult to achieve or grab that right. But here, this is the law. The beauty of RTI is this, that it has created a practical regime. I would like to give an example of this practical regime. The best of the best example would be if there is an illiterate person who cannot read or write. He goes to one of the officers and asks that, look, I want, one of the officer, meaning thereby some government servant, government office, he wants some information from the government office. He says to that government office that I need this information. Now the Act provides that if that particular individual is unable to produce it in writing, the officer which has to supply this information will himself write an application on behalf of the person who's seeking the information. What a beauty. So, meaning thereby, it is the practical regime where right to information is granted to each one of us, each one of all the citizens, as I may say. And what further, it is nothing. I will come to the most crucial, what you call, most important section of the Act. I will be talking about the key aspects of the Act later on. But it gives this right to all the citizens. Citizens have right to access to the public, any information, be it anything, they can ask if it is under the control of any public authority. Now, what has happened earlier, because we are here on this, how this has given importance to each one, this right has given to each one of us. What I wanted to say very, very clearly, that if this right is given, now the Act provides for, within itself, if I have a right there should be a legal obligation on the part of somebody. So I'll come to that as well. But the two fundamental things, two fundamental words say for a successful democracy or vibrant democracy or a democracy which if it is working in its best, the two words which are the key words are accountability and transparency. Now, accountability and transparency in the working of public authority. If there is an account, if the public authority, public officer is accountable to its people, then what I feel, there will be no problem in working of the system, working in the system rather. Similarly, if there is a transparency, you will be having right to ask a question. You will ask a question why this has been done and why this has not been done. You will be able to put a question, as I said earlier also, once you have the information. If you don't have the information, how you will be putting that, what will be the right scenario? So this is the act which has given us this strength. Now, I was in the beginning, I had also said that this law is one of the key laws for a vibrant democracy. Now, as in the beginning, I had said that for a nice working of a democracy, if an informed citizen is what you should have, and that is what this act does. Now, other benefits which we have seen in past 1.5 decades of working of this act, that it has helped us in curtailing the corruption in the system. If you may ask me how it has helped, a very small example I will give you, and then I will come to the various provisions and so many other things which are there in my mind. Now, if there was some information, what used to happen earlier, we used to go to the authority, we used to ask the authority, please provide us what you have done for this tender, let's say. The authority will say, application, we will tell you, till the time this RTI was not there. And they used to keep the information pending with them. And you go there, you ask them again, they will say, oh, we'll work on it, please be. So it was working on their own leisure. They were working on their own leisure. But this act has given a time frame also. I will come to that. And it become obligatory. If the person has desired some information, the other person will have the obligation to give the information, to furnish the information. I was reading an article, I don't remember who has written this article, in praise of the RTI, rather in honor of the RTI. This author has said that after this law, we feel that democracy is working in its earnest now. It has given the power to the very common person. It has given power to a very, very downtrodden person. A deprived person has been given the power by this act. Government, of course, once there is a fear in the mind of the officer, executive, the government, as we say, if there is a fear that, look, if somebody comes to know about this particular thing which I'm doing, and there is a chance that that individual will ask a question from me, then certainly that person will not, that particular authority will not indulge into any kind of malpractices, any kind of corruption, any kind of other things. So, and the work will be 100% in favor of the country, in favor of the masses, in favor of the public. And similarly, like as I was giving the example of tender only. So if there is a tender and there is an accountability right to a right to RTI is there, you can very well after the tender secure what people have given the price, what are the tender process, how it, whether it was transparent or not. So there is an element of accountability which is there on the part of the government officials. They are accountable. So these are the two major principles, accountability and transparency, upon which this entire act is dependent. As I said, it has given us a practical regime. It has not given us any very stringent or very strict formula to obtain any information. A very, very practical, and I will come to that also. That is one of the very, very important and a crucial, I would say, section of this particular act. Section 6, we will come to that. Now, on one particular ground, rather I would say a demand is being raised that why RTI is only for the public authorities, why it is not there for the private persons, private authorities, why it doesn't include the private persons. Then the answer to it is, I would say that there are many other bodies. I will give you a few examples here also. There are many bodies which regulates these private persons. Government authorities are regulated by RTI, Right to Information Act 2005. So as far as private sector is concerned, we have to not forget that there are other bodies which are regulating them. I can give you examples here. The best example is we have now various private banks. Now, who is regulating these private banks? These private banks are regulated by RBI. RBI, time and again, on the day-to-day basis, how they have to, what kind of fiscal policy they have to adopt, what kind of monetary policy these banks have to adopt, what is the priority sector lending they have to do, which sector they have to push. Everything is guided and decided by RBI. And above, parallel to that, if the consumers have any grievance, where they will be going? They can very well go to the another set of mechanism is provided in the shape of ombudsman. Banking ombudsman is provided. So what happens is, if you have any grievance with these banks, they are private banks, they are not covered under the purview of I would say the RTI, then you can very well go and file your application before the ombudsman and get your dispute redressed. Similarly, another example, we have seen a lot of insurance companies are there. Now, these insurance companies, private insurance companies, and if I may number here, there must be somewhere around 70 plus private insurance companies are there in this country. In my country, there are about more than 70 private insurance companies which are doing a lot of insurance, both journal as well as life insurance. For them also, if I may ask you, you cannot put an application in the RTI, but certainly there are two bodies like IRDA is there. You can ask if there is any question, if there is any problem, if there is any grievance, you can go to the IRDA. And parallel to the banking ombudsman, we have insurance ombudsman for the insurance cases. So rather, if I may put this in a way that for the private sector, you cannot tell me even a single sector which does not have a somebody or the other watching them also. So you have all rights to seek access and get information from them as well. Now, this is broadly as far as the basis on which RTI rests in this country. Now, what I wanted to tell you something about law specific, as many of new budding lawyers are here in front of me today. So I would also like to just convey to you, show you certain very important provisions of RTI Act, and I would also mention certain sections. If you could just read them, because it's not possible to elaborate each and every section in front of you now in this short period. So you must see section 2 of Right to Information Act 2005, which provides a lot of definitions. What is information? What is right to information? Section 2F is there. What is information? Section 2J is there. What is right to information? So these are the definition sections I want you to please see. Then I would straight away come to the most fundamental provision of this act. As I said, the practical regime. Section 6 is what says, which provides for what and how application under RTI is to be made. So very well go to any public authority. In each government office now there is as after this act, each government office has to have a public authority where you can apply for the information under the RTI. And section 6 is what you have to move the application under which. Section 6 is the right section, and the best part, if I may take 2 minutes and explain it to you, I think, because I feel that as this act has given power, it has empowered each one of us, each one of the citizens. So you should, I presume that all of you are well aware of it, but despite that, I will take 2 minutes and explain you what and how you should prepare an application under Right to Information Act. You have to write an information to the public authority, whatever is the department's name, application under section 6 of the RTI Act. Sir, please provide me the following information, following documents, whatever is their thing. One thing you must keep in your mind, that your questions which you put to the public authority should be very, very clear and very neat, in a very, very neat manner, and very explicit and manner you should ask, so that the person who has to reply your query should not, get diverted, like whether this is this or diverted, or get confused whether this information is asked or this information is asked. So it should be very clearly mentioned. It should be very, very explicitly mentioned that you want so and so things. Now, the best thing with relation to section 6, I would say the most important provision of this act is section 4. As I said in the beginning, that if you have a right, then there should be, as per the principle of law, there should be somebody who should have a duty. So the duty or obligation is on the public servant, on the public authority. The public authority will provide you the information. That is section 4. And these are the two sections, section 4 as well as section 6. You must go through them thoroughly, because these are very, very important sections, and these will give you an idea how beautiful this right is which is given to you. Now, I will come to another very pivotal, I would say, provision of this act. Now, what is that? That is section 7. Then section 7 provides to us that within what time frame the information is to be furnished to the applicant. The section very specifically mentions that the information which is desired by the applicant should be furnished within a period of 30 days. And other very important other thing which I would like to tell you here, that if the information pertains to life and liberty of somebody, then this information has to be provided within 48 hours of the liberty. So 48 hours of the application. So if there is a question of life and liberty, the information has to be provided within 48 hours. So a time-bound information regime is created for us. What a beautiful provision it is. That, and the other thing which I want to tell you here is very important. I must say why and how it is important, because if within 30 days, if this time frame is provided, a statutory limit is given to you that within 30 days this information is to be provided, or within 48 hours this information has to be released to the applicant. Now, if the information is not given? Very nicely, though this thing, if I may say, in various other laws also, including Consumer Protection Act, there is a time frame provided that within this period the application is to be disposed. The petition claim has to be disposed. But if not disposed, that does not, the consequence is not mentioned in the Act, Consumer Protection Act. But here in this Act, the lawmakers have provided the consequence also. We will go to section 20. Section 20 says that in case the application which is moved is not answered within the period of 30 days, the public authority will be liable to pay penalty. What a beautiful provision. A penalty at the rate of rupees 250 per day. And if this period is longer, then this penalty can go up to rupees 25,000. So, and this is what a right and obligation, as I was saying. Now, sometimes the other thing which I wanted to tell you today is that this Act has really developed a lot. This Act has, if we start from 2005 till date, this Act has opened its, it's what I should use, its income base. It has its reach has increased a lot. Now, a very recent judgment, I want to quote that judgment because that is one of the key judgments I feel, and it reminds me that I did two shows also on Rajya Sabha TV on this. That is the judgment wherein Supreme Court has held that office of CJI comes with the ambit of RTI. Now, what had happened, I will take 2 minutes and explain you what had happened in the year 2007. One applicant has moved an application before the Supreme Court Registrar seeking certain information pertaining to the judges. The Registrar Office of the Chief Justice of India denied the information, stating that we are not covered within the ambit of RTI, and because we are not the public authority. Now, this person, he has made an appeal, and thereafter CIC has given a very landmark judgment and said that yes, you are covered. Yes, if the information sought is of the nature that it doesn't disturb, it is not pertaining to the, if I may say, the working of the judiciary, then, and it is relating to the administration, it is relating to the administration, then you can very well ask and then CIC has decided it in favor of that individual, Mr. Subhash Agrawal, if I may remember the correct name. Thereafter, the registrar of the Supreme Court has gone to the Delhi High Court, and Delhi High Court initially passed an not initially. Delhi High Court immediately after hearing both the parties have decided the matter and has said that the decision of the CIC is correct, and it was held that yes, judges are also public authority and the information you have to furnish. Now, very beautiful thing I wanted to mention here, that Supreme Court registrar has filed an appeal in Supreme Court itself, and three bench judges initially restrained the order and gave a stay to the order, that this order is they stayed the order, and then referred the matter to five judges bench, wherein I think in the month of if I'm not wrong, December or November of 2019, this judgment had come, wherein the five judges bench has let down that CJI's office is a public authority, and any information pertaining to the judges or the working, etc., if it is required, it has to be if it is required, then you have to on an application you have to furnish the information. Now, of course, this judgment was, as the judges had stated very clearly, that in right to information and right to privacy are the two sides of a coin. This is what was mentioned by the judges concerned, and it was also said that this RTI cannot be used as surveillance tool for any judges, etc. And it was also stated that no doubt judicial supremacy, judicial independence is utmost. But yes, in case some information which should be in the public regime, why should it not be? And why, for example, the judges in the order has stated very clearly that if there is a information regarding the property details of a judge, yes, it should be open to the public, and public should see what is what is the information. It should be in public regime. Similarly, the judges have also given example of like how a judge is appointed, why a judge is appointed, what is its promotion, why this judge is transferred. These informations will not be furnished. So this is how this law has grown. I wanted all of you to know this judgment. That is the reason I mentioned it. But certainly the judiciary has given a very nice explanation to then they have also evaluated in that judgment what is right to privacy and how you can you cannot enter into the personal life of anybody, including judges. So privacy have the privacy. Privacy has the priority. So you cannot do the surveillance. That is what the word used by the Supreme Court in this judgment. So very nice judgment. You must see that judgment as well. So coming back to the point that, as I said, that it is very, very important right which is given. Now I would also like to touch base certain one very important point, which is this, that what are the exceptions for the disclosure? Which are the information which cannot be disclosed? And then there are certain also these grounds are mentioned in section 8. And if I may say, section 9 is also very important. Section 9 says that what are the grounds under which a application can be rejected. So section 8, which says that what are the exemptions, which includes, if I may say, sovereignty and integrity of the country. If anything, any information or disclosure is asked on sovereignty, which has an impact on sovereignty and integrity of the country, then such information is not covered within the Right to Information Act. Similarly, they have very specifically in section 8, if you go through the section 8, it says very clearly that anything which is explicitly prohibited by the act passed by the parliament, anything which covers parliamentary privileges, anything which let's say some details about the discussions within the cabinet meeting, such informations cannot be passed on under the Right to Information. Fiduciary relationship, what is the personal relationship? Fiduciary relationship is relationship between husband and wife, friend, between girlfriend and boyfriend, between master and servant. What is the discussion which has taken place, which covers, or anything like some trade secrets? You cannot ask somebody that what is the trade secret, what is the information, commercial confidential information as we call. So such informations can also not be furnished, are exempted very specifically by the act itself. Section 8, it's specifically said. Now, other thing, like any information which endangers anybody's life, such information cannot be given. Now come to section 9 also. I will just touch it. Please read section 8 as well. So the key sections are section 4, as I said, obligation. Section 6, I said, is the most important section, is section 6, which provides that what is the, how you have to obtain the information. Then section 7, I said, which gives the limitation within what period the information is to be given. Section 8, what are the exemptions, as I said, sovereignty, integrity of the country, etc., etc. Please read these sections very carefully. Then you also see section 9, which says, like, very good example given where the application can be rejected. Now, how it can be rejected? Application can be rejected by if the information sought is violating anybody's copyright, patent. So that information is to be restricted. Now I have to see the time also, but certainly I want to say very, very clearly that this is one of the most fundamental of the fundamental laws passed by this country in last 7 decades. I would say this has not only enriched our democracy, this has given power to the weakest of the weakest person, weakest of the weakest citizen, to be very, very specific. There is a debate we can have on who is a citizen, who can apply for it. So there are various angles to it. So I now request Simran to please, if anybody has any query, anybody has any question or any clarification, if anybody wants, I am open for it. I have just given a very small, brief introduction or whatever you can say about RTI. That's what I can say, and I am open for it. And I have got the privilege to appear before CIC, and I've seen through this act in a very close manner. That's all.
Thank you so much for such a fruitful session, sir. The first question is, can an individual file RTI without an advocate, or the advocate is mandatory to file an RTI?
No, advocate is not mandatory at all. You can very well file RTI without the help of any advocate. You don't need any advocate.
So second question is reducing the tenure of the Chief Information Commissioner and bringing the salary and perks as per the government discretion and interference with the institution, transparency, and finally the democratic fabric at the end of the day?
Well, I was expecting this question. This is, and I'm expecting 2, 3 more questions, which, most of the people, whenever we
Am
talk
I
about.
audible, sir?
Yes, I am audible to you or not? I've heard the question. I'm audible?
Yes, sir.
Yeah. So I was expecting this question. This is we have seen very recently there is an amendment by, as you have mentioned, and there is a big, voice from one side of the people who have said that this law as amended has really, with after coming into effect of this uh, particular amendment, the the working of RTI must have, it will it will be it will be it will not remain the same, and on various issues the government will get favors from the authorities, as now the authority, and meaning thereby the people who have to deliver the CIC and all those the quasi judicial officers, they will be influenced by the government. That's what was the demand from the other side. But what I say, to a great extent, of course, if somebody is controlling me, somebody is controlling me, somebody has to on my, each and every move. So of course, if I have to give a decision where the discretion is to be used, my discretion will be in their favor. But if I may say one other aspect of it, that we, as a matter of fact, we should not always, see everything with lenses. That is another aspect, which says that in case, otherwise everything will be like that. Everything you can very well challenge any part of it, that look, government is doing this. If you start putting lens on anything, you will. But certainly I would say that if this kind of apprehension has come into the mind of people, then I would suggest that such measure which is being taken by the government should be, they should answer it. They should come up with a answer to it. Why such thing will not happen? Why not the government should come and remove this apprehension? So that's what I feel. So to me, yes, I feel that it has some impact. That's what I can say.
So next question is, can we file an RTI to know about the cash deposit in someone else's bank account in case the payment was made by me and the recipient still denies of having received the payment?
No, look, this is not difficult at all. For this, I don't think you should go for RTI. First of all, Section 11 is there, the third party information you cannot take. That is there. But the answer to this question is, it is very easy. Why you are going and filing an RTI? Your bank will give you a certificate. If your money has gone to some other person's account, your bank will provide you a certificate. Look, on so and so date, so and so amount has transferred to this and this account, which is held in this bank. So your bank, you need not to go for an RTI. And of course, as I said in the beginning itself, that in case you have some grievance against a bank, please go to the ombudsman. Banking ombudsman is the best way. Where is the need to even waste 30 days? Go file an application. Within 8 days, you will get your reply. And most important, as far as the banking ombudsman, insurance ombudsman, RBI, IRDA, these are the bodies where you get very quick redressals. That is what, with this, by virtue of this medium where we are discussing, I wanted to tell all these budding lawyers, all the listeners here, that these are very efficient bodies. And we have seen that in past few years, the scope of these bodies have certainly increased. The use of these authorities are being increased, but certainly there is a lot of more scope. People are less aware about these bodies, ombudsmen, etc. They should go and ask. They should get their problem redressed there.
Sir, final question for today is, do you think as RTI is not applicable on private sectors, it is a great loophole?
Well, I have said in the beginning of my discussion that RTI is not applicable to private persons. Now, I put this, who has asked this question?
Sir, China Abrol.
China Abrol, it's a very common question, in the sense that whenever we talk about RTI, this is one of the people always take this issue, why public sector is open. Now, Tina, I wanted to tell you very specifically, I put a question to you. You tell me which private sector you want to ask a question. I am telling you, every private sector has some or the other body, some or the other regulator looking into it. As I gave the example of insurance regulatory body, that is IRDA is there. Banks, private banks, you cannot file RTI, but you have RBI, you have banking ombudsman, similarly, so on and so forth. You name anything. If you want to, to the extent an individual, if there is, you have some grievance or to even to an individual, you can approach through these bodies like that. So I feel